Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, we're back in Calloway County with attorney Jeff Roberts. Jeff, how you doing?
I'm doing good, Jim. How are you today?
Well, I'm doing fantastic. A lot of the cases that you handle happen to do with injuries. I mean, they happen to deal with injuries of some sort. They're either a personal injury case, they're probably a workers' compensation claim, or something related to Social Security disability. And one thing that comes through is the term contingency fee. And that confuses a lot of people. So why don't we spend today's episode talking about what is a contingency fee, why is it a good thing for a consumer, and how does it actually work? So we'll kick off with that, and I'll throw the ball to you.
Okay. Contingency fee basically is a fee that is contingent upon the recovery. So essentially, if there is no recovery, there is no fee. The fee is going to be a percentage of what the recovery is in the case. And you see that a lot of times in personal injury cases, that the case has been handled on a contingency basis. Part of the reason for that, and the main reason for that, is with the use of contingency fees, it allows basically anyone and everyone to have access to the courts when they've been injured. A lot of people in this country could not afford to pay a large retainer and an hourly rate to an attorney to handle a case, because if they just don't have the financial means to do that. So without a contingency fee, essentially the courthouse doors would be open to large corporations, wealthy individuals, but the courthouse doors would be essentially closed to anybody who's wanting to fight an insurance company or a large corporation because they were injured by somebody's negligence. So it allows the courthouse doors to be open from that standpoint. And now the percentages can vary depending on the type of case, depending on the law firm. Along with a contingency fee is also that in Kentucky anyway, the expenses in the case can also be contingent upon recovery. Some attorneys do that, some attorneys don't do that. What that basically means is that the attorney would advance the cost of the litigation, filing fees, deposition fees, expert witness fees, things like that.
You may have to travel to go see an expert in a case or something like that.
Exactly, right? Travel expenses. If I had to travel to Louisville to take an expert's deposition, the travel expenses there. If I had to spend the night, and potential hotel expenses, things like that, all are part of the case expenses associated with the case. And some attorneys will handle the case to where the expenses are contingent upon recovery, which means if there is no recovery, then the attorney doesn't get paid an attorney fee, and they also don't get reimbursed their expenses. Some attorneys don't make the expenses contingent upon recovery, so even if there's still no recovery, the client would still be responsible for the expenses that the attorney incurred. Now, myself, that's not the way I handle it. The expenses in my office are on a contingency fee basis as well, which basically means if I am successful in the case, I get paid an attorney fee and reimburse my expenses. If I'm not successful in the case, if there's no recovery in the case, then I don't charge an attorney fee. I don't get paid for the time I've spent and my office has spent on the case, and I don't get reimbursed the costs I've expended in presenting that case for my client.
That puts a lot of pressure on you, but for the consumer, for the injured person, it really takes a lot of weight off their shoulders, because they know, hey, if Jeff Roberts takes this case, he's got a lot of skin in the game.
Correct. Yes, I have a lot of skin in the game in that regard, and it's. I've often had clients ask me about that from that standpoint, and what I tell them, and it's the way I feel about the situation. I've had times in the past when I've had a problem with my car. I've taken it in to the mechanic to have it fixed. They replace a part, doesn't fix the problem. Take it back, they replace another part that does fix the problem. Well, I had to pay for the part, and for the first visit, I had to pay for the second part, and the second visit, from that standpoint, and it never felt fair to me. I didn't know what was wrong with my car. I relied upon them to figure out what was wrong and fix what was wrong. From that standpoint, and it just never felt like that was the right way to do it. So when I handle these type of cases, the clients come in to me. I'm the one who tells them, yes, I think you have a case here, and they're pursuing that case because I've told them I think they have a legitimate case there, and then to turn around if we aren't successful, which doesn't happen very often, but it does occasionally happen. If we're not successful in the case, then say, well, unfortunately, we weren't successful, but I spent $5,000 in expenses, in expert witness fees, etc., in representing you in this. So now you owe me $5,000, and they would never have incurred that cost if I had told them up front, we're not, you don't have a case we're going to win. I don't think it's fair to the client to do that, and so I just will not. That's just not the way I handle a case.
Well, and that's the honorable way to do it, in my opinion. I mean, if you're going to take on the risk, take on the risk.
Exactly. Yeah, I agree with you. And if somebody's going to rely upon my advice and then something doesn't occur the way I thought it was going to, I should be the one that basically suffers that loss, not the client.
That makes sense. And while the contingency fee allows everyone to have access to the legal system, it is a significant advantage under our law. Sometimes an attorney won't take the case in an injury case, and some of it may actually have to do with the fact that this is going to be expensive to litigate, and we don't know that the facts are necessarily on your side, and that does have to come into it at times. It
does have to come into it. I've talked to clients before, and I've told clients that, look, with the value of your case, after what you pay me in attorney fees and expenses, where you're likely to come out versus where I think the carrier may be with you on a settlement is going to be real close to the same number. And, there's no sense if it's and I'm just going to use an example, but if it's a case that I think is a $15,000 case, and I think the insurance company will offer probably around $10,000 on that case, even without an attorney being involved. Well, if I'm handling that case on a 1/3 contingency fee, so I get the $15,000 I think the case is worth. $5,000 of that, the 1/3 contingency fee, is paid as an attorney fee. The client's no better off in that situation. And I've had that conversation with clients. If it's a case that I know is going to cost $20,000, $30,000, $40,000 to get in front of a jury in expenses, it's not a lot of cases that do that, but there are some that are that way. And if it's that type of case, and the likely recovery in the case, we're going to have $40,000 expenses. The likely recovery in that case is $35,000, $40,000. It doesn't do anybody any good to pursue
the
that
math
case.
doesn't work out even for the victim.
It does not work out for them at all. I mean, they go through protracted litigation, which is extremely stressful for individuals. I've had a lot of clients tell me when we've resolved a case how big of a weight that's been lifted off of their shoulders to have that litigation over with from that standpoint. So to put a client through protracted litigation when it's really not going to be ultimately beneficial to them is just not doing a person the way you ought to do people. You should treat people the way you want to be treated, and that's certainly not doing that.
That makes a lot of sense. Well, let's break it down. Let's look at it from a personal injury case standpoint, a workers' comp standpoint, and then also a Social Security disability insurance standpoint. So let's start with a PI case. Usually a car wreck case is what we're talking about mostly, or a motorcycle accident, something to that effect.
Correct. A car accident case, obviously it's still contingent fee is the same thing. Now the percentages are going to be different for different types of cases. For a car wreck case, at least what I practice on those is 1/3 of the recovery. So 33 1/3% contingency fee plus the expenses that I incur in that case, again, contingent upon recovery as well. Some attorneys have increased their fees on car wreck cases up to 35%. I've seen some contracts, or at least heard some attorneys have gone up to 40%. I know there's some contracts I've seen where they charge 1/3 of the recovery if it's settled without filing suit. If it's suit's filed, then the fee goes up. If it goes up on appeal, the fee goes up again. And I understand why that is. That's not the way I handle it. When I take on a case, the fee is for me to handle that case to completion. And if it goes up on appeal or I have to litigate it further, that's nothing the client's done to cause that issue whatsoever, and I don't think they should incur additional costs. So I don't do that. My retainer for a car accident case is 1/3 of the recovery, whether we settle it pre-suit after litigation's filed, or we go to a jury trial and it gets appealed and we have to take it as far as we have to take it before we collect. It's still 1/3 of the recovery.
That's interesting. You're one of the first attorneys I've spoken with. I've spoken with a lot of them over the year that actually has that policy. I applaud you for that because I do know a lot of them, because it does cost a lot to prep for trial and to get a trial successfully in front of a jury. And they do elevate their fees. Now that's in their contracts, but it's something that they do. And the fact that you don't, we'll phrase it this way, penalize the client,
Correct.
For that fact, that's admirable.
Yeah, that's the way I do it now, and the way I've always done it. From that standpoint, obviously you never know what the future is going to hold, but I don't anticipate anytime soon changing that. I do have one provision in the contract that where the fee does go up to 40%. I've never had to use that. And I put that provision in several years ago because of an attorney friend of mine had this situation occur where there was an offer on the table that they had recommended to the client, recommended it before their offer had been put on the table, even that if we get them to this dollar figure, we need to settle. The attorney got the insurance company to that dollar figure, and the client said no. They ultimately tried the case, recovered less money than what the offer was, and the attorney did not have that provision in their contract, and so they ended up recovering less money than what they would have if the client had taken the offer that they had recommended to them. And after that occurred, several of us talked and said, it's probably a good idea to include a provision in the contract that the fee goes up if there's an offer we've recommended in writing that they reject, that's actually on the table. I've never had to use that provision in my contract, but it's been in there for several years now because of that situation.
Well, and I think part of the reason people hire you is they trust your judgment, they trust your experience, and they know that they're going to get advice from you. And sometimes people just need to listen to their attorneys.
Absolutely, that's the case, and I hope people are hiring me because they trust me from that standpoint, and that's, I think, the reason why I have not had to use that provision in my that is in my contract. I let the clients know that when they hire me that it's in there from that. But I think I've had lots of clients tell me when we got a settlement offer on the table, and they'll say, well, whatever you think is best is what we're going to do. And I appreciate that. I still tell them, I said, look, I understand. I'll tell you what I recommend. I still have to tell you what the offer is and what my recommendation, and then ultimately you're the decision maker. If I tell you to reject it, you still have to tell me, yeah, I reject that. I'm going to take your advice and reject that offer. So it's ultimately their decision, but hopefully they will listen to their attorney.
Well, and it comes down to trust. And friends, I'll tell you, if you have any doubt about Jeff's the way he runs his firm, go check out his Google reviews. He's got tons and tons of 5-star reviews, and those aren't just done for the heck of it. Those are reviews that have been earned by Jeff and his team here, and you do a great job down here. I mean, you really do, and that's why I think other attorneys across the state actually bring you into cases when they get complicated, when they have special matters that you have a certain amount of knowledge about and experience with. It's not uncommon for Jeff to get a call from one of his colleagues saying, hey, would you mind stepping in here?
That is not uncommon. I do get associated with or contacted to associate with other counsel frequently. And frankly, when that occurs, it's something probably ought to be mentioned in the podcast. If you've already signed a retainer agreement with another attorney that has a different fee arrangement, if I get brought in, first off, it doesn't increase the attorney fees to the client in that situation, but it also doesn't decrease the attorney fee. So if you've signed one that's got the 33 1/3% and then it goes up to 40%, bringing me in doesn't change that retainer there, even though that's not the way I normally work. The retainer that's been signed is the one that we're going to go by when we ultimately
well, and that's an interesting point, though. Just because they have multiple attorneys involved doesn't mean there are multiple attorneys' fees being deducted from your claim either.
No, it does not. And I've had conversations with clients before and to explain that to them for that reason. And so, yeah, some think, well, okay, there's a 1/3 contingency fee, and then we bring Jeff into the case, and so now this attorney A gets 1/3, Jeff gets 1/3, and there's only 1/3 left for me in that situation.
It doesn't work that way.
It doesn't work that way. The fee is 1/3. Client gets 2/3 minus the expenses out of that 2/3, and then the attorneys will divide up that 1/3 based on the agreement they've reached and the amount of work each has put into representing the client in that situation. So.
That makes a lot of sense. Jeff, let's transition over to workers' comp because it is a contingency fee, but attorneys' fees are actually handled a little differently than civil cases.
It is. I handle the cases on a contingency fee in workers' compensation cases. The only type of case that I don't handle on the contingency fee is a small type of workers' comp, which is called a medical fee dispute. And I'll talk about that in a second. But normally, in a workers' compensation claim, I'm handling that case on a contingency fee. The fee in a workers' comp case, though, is set by the statute. I don't have control over the percentages I charge. There is a cap on the attorney fee in a workers' compensation case as well. In the statute, the way it's on a graduated scale, the politicians made it a heck of a lot more complicated than I would have made it. And so the fee on that type of case is going to be 20% of the first $25,000, 15% of the next $25,000, 10% of anything over that, capped at $18,000. So the attorney fee would never exceed 20% of the recovery. It will never exceed $18,000. But depending on the recovery, I can't tell a client going in, well, the attorney fee is going to be this percentage because I don't know exactly what that percentage is going to ultimately be because of that graduated scale.
But the good news is that's on the books. That is Kentucky state law. That's how it's going to be handled.
Correct. That's how it is going to be handled from that standpoint. So, and again, at least the way I work on on workers' comp cases is the expenses are also contingent upon recovery, the same as in a personal car wreck type case from that standpoint. And then some attorneys do that, other attorneys do not do that. In Kentucky, on a workers' compensation case, the fees that you're being charged should be the exact same for any attorney. It should be that 20%, then 15%, then 10%, because that's what the statute says. There should never be a fee. You sign a retainer that says anything different as far as the fee structure goes from a general workers' compensation case in that regard. And in workers' compensation cases, actually, the ultimate fee that I charge to the client has to be approved by a workers' comp administrative law judge. And it's not just I charge. It's not that, okay, Jeff, we're going to make you get yours for anybody who represents a party in a workers' compensation case has to file a motion to have their attorney fee approved. I represent the injured party. I have to file a motion. Any other attorney that represents the injured party has to file a motion and the judge approve it. And the attorney that represents the employer or insurance carrier has to do the same thing.
Well, it's yet another safeguard that Kentucky workers' compensation law has put into place to protect the injured worker. And that's another benefit about, filing a claim. If you have to actually file a claim in Kentucky, there are some benefits out there that really, and some laws that actually protect the injured worker. And I think that's kind of how it should be.
I agree. It should be that way from the standpoint of, and I don't know that I agree that a judge should have to prove it. I think we could do it with an affidavit of the attorney saying, this was the recovery, this was the fee I charged, it was within the confines of what the law allows, as opposed to a judge actually having to say that is an appropriate attorney fee in the case. But having a judge look at it to make sure that the fee is in compliance with the statute is fine. Whether I agree with the statute or not is a different question.
Sure.
But making sure that the attorneys on both sides are complying with the statute is something that I think should occur. And most attorneys who practice workers' compensation cases on whether they represent the insurance company or represent the injured worker, know that, and there's no problem with that aspect of it. Where you will see problems come in is somebody who rarely does it and doesn't realize there's that cap on the attorney fee, and they'll tried to charge greater than what it is, and the judge has to kind of slap their hand and say, no, you're limited to this amount in this case. So.
That's why your family law lawyer should not handle your workers' comp case.
Or exactly, yeah.
Well, Jeff, you said at the beginning of this section, working specifically with workers' compensation, that there is something called a medical fee dispute, and that's handled a little differently. Let's jump into that.
Okay, a medical fee dispute is whenever I resolve a workers' compensation case, the vast majority of the time, the future medical for my client is left open. So the insurance carrier, the comp insurance carrier, is responsible for reasonable and necessary medical associated with the work-related injury for a minimum of time frame of 15 years from the date of accident, potentially lifetime, depending on the nature of the injury and some other things.
At least that's how the law is written today.
That's how the law is written today. Yes. In fact, it was lifetime always until July 2018. But now it's 15 years with the potential for lifetime, or if you're totally disabled or have certain other injuries, then it's lifetime automatically, even today still. But the insurance carrier can challenge future medical treatment, saying it's not reasonable and necessary treatment, or the treatment's not for the work-related injury. And when they do that, they file what's called a medical fee dispute. And in that situation, I'll have clients come back in and say, okay, I've got this document. What is it and why did I get it? And I will explain that to them. But if we litigate that case, there's no money going to the client. If I'm successful, the doctor gets paid, and the client gets the treatment that's being challenged, but the client doesn't get any money. Well, the doctor's not my client, so I cannot charge the doctor an attorney fee. And so in that situation, the fee is paid by the client at that point. Now, very, very rarely, if the carrier is acting somewhat bad faith. Bad faith doesn't apply in workers' comp, but that's the best way to word it.
So they're being squirrely.
Yeah, it's called, exactly. If they don't have a reasonable foundation, and the judge finds that, the judge can make them pay the attorney fee. That's a rare occurrence in Kentucky, at least in my experience. It's a rare occurrence in Kentucky. And so the client has to pay the attorney fee in that situation. And since the money's going to the doctor, I don't know how much the doctor gets paid. I can't do it on a contingency basis from that standpoint. So those are the only cases I handle on an hourly rate basis. And in those cases, I do require a retainer and an hourly rate, like other attorneys who handle hourly rate cases all the time. But that's pretty much the only situation that I ever handled a case on an hourly rate basis.
Good deal. Good deal. Well, let's wrap up today's episode with a discussion of how it's all handled in Social Security disability insurance claims. Now, again, SSDI is different from Social Security retirement funds. It's different from Social Security Supplemental Security Income, which is SSI. We are specifically focusing on SSDI today for this conversation.
And with SSI disability and Social Security disability insurance, or SSDI, are handled the same from a fee standpoint. And it's, again, a contingency fee, and it's kind of controlled somewhat by the Social Security Administration as well. The fee's got to be approved by the judge, or the fee agreement approved by the judge. If you handle Social Security cases, if you're an attorney who handles Social Security cases, if your arrangement with your client complies with the Social Security regulations to have the fee agreement itself approved, then the judge would approve the fee agreement, and then Social Security would pay the attorney fee to the client. They don't approve the exact dollar figure when they do that. They just say the fee agreement's appropriate, and the administration will comply with that. And in those situations, but with Social Security cases, the way I handle them is, which is in compliance with the Social Security regulations, is the fee is 25% of the past due benefits, subject to a cap. The cap can change from time to time. I've been practicing for 20 years. I
thought that was a little short.
Yeah, that's a little short. I've been practicing for 30 years. And during that period of time, the fee cap changed one time. It was last year. So it's gone up to $7,200 on that. So if the attorney agrees that their fee would never exceed 25% of the past due benefits and never exceed 7,200, the judge would approve that fee agreement. And then if the back pay is $20,000, they would Social Security automatically withhold 25% and pay me the attorney fee. If the back pay is such that it would exceed the $7,200 fee, Social Security would send me a check for the $7,200, and then the rest of the back pay would go to the client in that setting. Again, in Social Security cases, I also advance the litigation costs, and those costs are contingent upon recovery. So if we are successful in the case, I get paid the attorney fee by Social Security. The client would pay me the expenses when they get their back pay. Now, and I say Social Security pays the attorney fee. Social Security sends me the check. Client pays the fee because it comes out of their back pay. But the check is coming from Social Security. When the client gets the back pay, they come in and pay me the expenses from the back pay check from that standpoint. Some attorneys don't do the fee agreement process, and they do just a straight 25%. And if that case, you've got to have the judge approve it, but the fee could be greater than the $7,200, and they have to approve the specific fee in that situation. Not many attorneys handle cases that way, but there are a few in the country that do.
Okay, and again, you said in the country because Social Security is a federal program. So again, you could actually represent people across the United States in Social Security disability claims.
Yes, I'm licensed by the Social Security Administration to handle cases before the Social Security Administration in all 50 states. During my career, I've handled cases in probably 8 to 10 different states total. Vast majority of my cases are in Kentucky. I'm in Murray, Kentucky, and have a satellite office in Hopkinsville, Kentucky, which is very close to the Tennessee state line. I handle quite a few cases in Tennessee as well. But there's been times where usually it's in cases where I represent a person in a Kentucky workers' compensation case who may live in Alabama or Illinois or Indiana, or something of that nature, and they want me to handle their Social Security case as well, and then I've represented them. I've had some clients who started out in Kentucky and me representing them their case, and then they moved to another state, and they want me to continue on. I've offered to say, well, if you want to get me to get somebody local for you, fine. If you want me to continue on, I will do so. And so I've handled cases in Florida and others from that standpoint as well. Still waiting for the client from Hawaii to call me, but
That might be a personal visit.
yeah, that one I may have to go visit them in person if I can figure out how to deduct that from my taxes. But yeah, I've handled cases in a vast majority of, or not a vast majority, but in several states before the Social Security Administration, and can handle them in any state.
Right, but again, those are capped, just like workers' comp. Those
Correct.
are capped, and it's really when we get back to the civil claims, the automobile accidents, the other personal injury types of claims, where that is a stated percentage, but it's kind of uncapped at that point. Correct.
Correct. It's capped. The attorney fee. It's the attorney contract caps it at a certain percentage, but there's not a dollar figure cap.
Right, not a
on
ceiling.
those,
Okay.
on those cases. Now, one thing that because I've talked about case expenses and advancing expenses in cases, and one thing I probably ought to make sure people are clear on is that an attorney can only advance litigation expenses, the case expenses to the case. So if my client doesn't have the money to go see a doctor for medical treatment, I cannot advance that cost. That's cost for medical treatment. That's not a case expense. Now, if it's a doctor I'm sending them to be an expert witness in the case, I can pay that charge. But for treatment purposes, I cannot. If they don't have the money to pay the rent, I cannot advance those costs to a client. There's a specific ethical rule under Kentucky law that says the attorney can advance case expenses. Case expenses can be contingent upon recovery, but it is unethical for an attorney to advance any money to the client that's not a legitimate case expense from that standpoint. And I've had clients that I've had to have conversations with, and frankly, there's been clients I've wanted to help.
It can be heartbreaking.
Yeah,
sometimes.
There's been clients I've wanted to help, but I'm not going to risk my law license to do that. And and so that's a situation where the people need to understand that if you go to the client and say, look, I'm a couple $100 short on my rent this month because of this car wreck or because of this work injury, can you help me out on that? When your client when the attorney says no, it's nothing personal. It's not that they don't want to help you out. It's that they cannot ethically do so. And if they do so, and the Kentucky Bar Association found out, they could potentially, or the Kentucky Supreme Court, whose ultimate decision on those type of cases, they could actually lose their license to practice law, and then somebody's going to have to help them pay their rent. So.
Absolutely. Well, Jeff, it's been a very informative episode, and I really hope people get a lot out of this. I think, there's always that hesitancy anytime you're thinking, wow, I've got to hire an attorney, or I might need to hire an attorney, because you do start thinking about the dollar value. But I think there's enough material out there to substantiate the fact that you're probably going to do better off in most cases if you do have an attorney on your side who understands the complexities, understands how to negotiate with the other side, who are skilled negotiators and who know how to work their side of the case. You need somebody protecting your rights, and sometimes it's worth paying to do that, and that's why we have a contingency fee here in Kentucky that allows you to get the ball rolling without having to come money out of pocket up front. And also, Jeff, with your personal policy here, protects them on the backside should you not prevail in the case, where they're not going to be out that cash either. And that's I think that's once again another reason why people trust the Roberts Law Office. I just think the way you handle yourself personally, the way you handle your firm, it just shows through. And I think that's the kind of clarity and the trust people are looking for in the attorney that they choose.
I hope so, and I appreciate those comments. And as I mentioned before, and I hope other attorneys, I don't sit in when the other attorneys talk to potential clients, so I can't talk about what other attorneys do from that standpoint. But as I mentioned before, if you come in to see me, and I think once you pay the attorney fee, it's not going to be beneficial for you to hire me, I'm going to tell you that right up front and let you know that going in. I couldn't give people's names, but there's people that I've talked to in the past this year and every year prior to that where that's occurred, where I've told them, I said, look, I think you're better off to do this now. If the insurance company offers you $2,000 instead of $10,000, you may want to come back in to see me. But this, I think, ultimately what the value of the case is, once you pay the attorney fee, you're probably going to get close to it from the insurance company. And I've had some come back in and say, yeah, they're only offering $3,000, and I may get involved in that situation. I've had others call me back up and say, look, I appreciate you being honest with me about the case, and you're right, that's what they offered me. So I ended up, and I knew from our conversations that it was pretty close what it'd all be worth. So
fantastic. Jeff, thanks again for your time, and thanks for taking the time to share this kind of information, because once again, I think it's just one of those areas when it comes down to hiring the right law firm that people have a lot of questions about, and I hope there's a lot of clarity now based on what's available in this episode. So again, thanks for your time. Thanks for your candor.
Thank you.
Take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.